ಬಂತು ಬಂತು. ಥ್ಯಾಂಕ್ ಯು. ನಮ್ದಲ್ಲ.
Submissions by large group. Asking written submissions.
Judgments ಮಾಡಿಲ್ಲ. No, but some, no, yes. I had to give only the, my lords, the tabulated statement. I also filed a memo as to how that 32 vacancies, even if they post, even if they are axed from the cadre strength, how it would not affect us.
Judgments.
Judgments I'll have to. Judgments I would take, my lords.
I would, we had a look
Yes, ma'am.
at your submissions of 9/1/26. Filed by you.
Yes, my lords. That is submissions I have filed on 15/12 synopsis. 19/12/6.
Field number 1162.
16/12.
Yes, in 1162. I have filed synopsis on behalf of the appellants.
No, who has filed this 9/1/26?
9/1/26. ಯಾರು ಸೊಂದಿ ಸರ್ ಹಾಕಿದ್ದಾರೆ? ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಸೀನಿಯರ್ ತೋರಿಸಿ.
That is not filed by me.
Sondi has filed.
ಅವರು
Memo. Maybe Dr. Sondi has filed. Memo that we have filed. 9/1 is memo.
9/1 is memo, my lords. Memo.
Correct. Memo only.
Yes, it is a memo.
In Deputation number 1166. Please refer.
9-1 is a memo
Correct.
which regarding the cadre strength.
No, this is filed by you, is it?
Yes, my lords.
Ah. So what we wanted you to take us through this.
Very well, my lords. I'll take it.
We are not able to digest fully.
Now, in fact, my lords had directed me to file it as a tabular statement. Then I tried to make a tabular statement. In the remarks column, I could refer only to the para numbers of this memo. Then I stopped it because ultimately whatever my learned friends were, thereafter I will appropriately correct that remarks and file. But as on today, I can explain this. Now, my lords, if my lords would take the division bench judgment in the opinion rendered by Justice Rajesh Rai, that is from para 58 at page 100. This is where the opinion starts. At para 66, my lords, page 108. In terms of the Karnataka Judicial Service Recruitment Rules 1983, the posts of district judges are to be filled. Could my lords get that page? News?
Yes.
Has to be filled in quota of 2/3 by way of promotion from the cadre of civil judges and 1/3 through direct recruitment. That is what the learned judge records his finding. That is wrong. I pointed out the judgment which went from the Madras High Court, where up maximum of 10 was there. Today I have been able to lay my hands on another judgment, Manoj, exactly in the Delhi Judicial Gopi Singla, Delhi Judicial Service, Higher Service, wording was identical. That is, not more than 1/3 of the post shall be filled by direct recruitment. That was, I had asked him to keep 3 copies here. Where is my copy? Identical rule in Delhi Higher Judicial Service was interpreted by the Supreme Court. That is, my lords, O.P. Singla, 3 learned judges, then the Chief Justice and 2 future Chief Justices. This pattern has continued, my lords. Wherever judicial officers matter come, more or less similar constitution of the bench is there. Para 16 of this judgment, my lords. Logically, we must begin this inquiry with the question as to the interpretation of proviso to Rule 7. Does the proviso prescribe a quota or does it merely provide a ceiling? In other words, does the proviso require that at any given point of time, 1/3 of the substantive posts in the service shall be reserved for direct recruits, or does it only stipulate that the posts held by direct recruits shall not be more than 1/3 of the total number of substantive posts in the service. The proviso reads, provided that not more than 1/3 of the substantive posts in the service shall be held by direct recruits. This language is more consistent with the contention of the promotees that the proviso merely prescribes, by way of imposing a ceiling, that the direct recruit shall not hold more than 1/3 of the substantive posts. Experience shows that any provision which is intended to prescribe a quota generally provides that, for example, 1/3 of the substantive posts shall be filled in by direct recruitment. A quota provision does not use the negative language as the proviso in the interest case does, that not more than 1/3 of the substantive posts in the service shall be held by direct recruits. Now kindly have a look at 1983 rules, my lords, which the 1983 recruitment rules is
Para 8, the judgment.
yes, my lords.
Para 8 of the judgment.
Para 8 of this judgment, my lords.
That same.
No, he is there. It is para 8. Our rule is para 8, rule 7. Rules 7 and 8, which are crucial to the controversy between the promotees and the direct recruits, reads thus. Rule 7, regular recruitment. Recruitment after the initial recruitment shall be made by by promotion on the basis of selection from members of Delhi Judicial Service who have completed not less than 10 years of service in the judicial service. Delhi Judicial by direct recruitment from the bar, provided that not more than 1/3 of the substantive posts in the service shall be held by direct recruits. That was the rule. Our 1983 recruitment rule also, page 691, volume 3. Madras High Court in the Supreme Court. Item 2 in the schedule at page 691. District judges, by promotion on the basis of seniority cum merit from the cadre of civil judges, provided that such number of posts as may be determined by the High Court from time to time, but not exceeding in the aggregate 33% of the posts in the cadre of district judges may be filled by direct recruitment. Therefore, the mandatory procedure or method of recruitment is promotion, with a provision that not more than 1/3 post can be filled up by the High Court, okay, by direct recruitment. Even 1/3 is also not mandatory, as may be determined by the High Court. Suppose the High Court says, I have excellent officers in the civil judges cadre, I will promote them instead of directly recruiting. It can say, I will not make any direct recruitment. Or if the High Court feels there is enormous stagnation in the civil judges senior division cadre, I have to take care of I have to inspire them for better performance. Some incentive has to be given to them. If the court may say 100%, I will fill up by promotion. There is no definite quota. This is what was said by 3-judge bench in O.P. Singla. And I already brought to my lord's notice your subsequent judgment. This is of 1984. Subsequently, my lords, 1994. That is judgment number 15, which I have placed before the court. That is volume 2 of my compilation of judgments, my lords. ಅಲ್ಲಿ ಕೊಡ್ರಿ ಸಾಹೇಬರಿಗೆ ವಾಲ್ಯೂಮ್ 2 ಮೂರು ಸೆಟ್ ಇದೆ ಎಲ್ಲರೂ. ನೀವು 3 ಜನ ನಿಂತ್ಕೋಬೇಕು ಸಾಹೇಬರಿಗೆ ಕೊಡುವಾಗ, 3 ಜನ ಸಾಹೇಬರು ಇದ್ದಾರೆ ಅಲ್ಲಿ.
Page number, sir.
Well, there is one of the, it is at page 286. It is a short judgment. At page 286. This is by two learned judges. Earlier judgment is not referred to in this judgment. Para 3 minutes. Sri Parasharan, the learned senior counsel for the appellants, has contended that the High Court has committed serious error in not giving the direction to for the appellant's confirmation to the substantive courts. Interested seniority between the appellants and the contesting respondents would flow from that direction. He contended that state government had fixed 31 posts of district and session judges, out of which 18 are for the district and session judges grade 1 and 2 posts are for 11 posts are for district 7 grade 2. In the seniority list published by the government of the cadre of district judges grade 2, placement of 28 to 33 has been kept blank, which meant that they are reserved for the appellants. The High Court admitted of their appointment to substantial vacancies and successful completion of their probation. Irrespective of the fact that the contesting respondents were promoted earlier in point of time, the appellants are entitled to be fixed in vacancies kept reserved for them in the placement. In that regard, he contended that once the appellants have been appointed substantially by direct recruitment, they should rank senior to the officiating promotees, and therefore the High Court has committed serious illegality in not giving the direction in that behalf. Having given our anxious consideration, this is the finding, my lords. Having given our anxious consideration to the contentions raised, we find that on the basis of the rule position, it is difficult to accept the contention. The language couched in Rule 2B of the TN State Higher Judicial Service Rules 1982 would make the matter clear. Appointment to Category 2 of the district and judge is from two sources, namely recruitment by transfer from the category of subordinate judges in Tamil Nadu State Judicial Service or by direct recruitment. While making a recruitment, the proviso limits its operation that out of the cadre, not more than 10 posts shall be filled or shall be reserved to be filled by direct recruitment. It does not indicate that this is meant to be up to a maximum of 1/3 of the posts of the cadre. Had the percentage of posts been linked with the total cadre strength, certainly direct recruits are entitled to occupy 1/3 of the post from the date of their affiliation and get seniority from the date of their appointment, subject to successful completion of probation, irrespective of the fact whether the promotees have been continuously officiating as district and session judges prior to the appointment of the appellant in excess of their quota. Their earlier promotion and continuance would not inure to their advantage, and they will be pushed down, giving place to the direct recruits within the quota. Unfortunately, Rule 2B does not prescribe any quota. It would mean that at no point of time the direct recruits would exceed 10 in number. Undoubtedly, the object of direct recruitment is to infuse young blood into the service to accelerate efficiency, and members of the bar opt for selection. To achieve the purpose, language of the rule should be different. Whatever may be objective in making direct recruitment, it is the language of the rule that would decide. When rule says not more than 10 persons by direct recruitment, it does not prescribe a quota, it fixes a ceiling. Quota is an entitlement. Ceiling with the word may fill up. It removes the very concept of quota. It is permissive. If the High Court feels direct recruitment should be made, it can be made subject to the condition that it does not exceed 1/3. If High Court feels no direct recruitment, I will fill up the post by promotion. This is what is said in Ashok Kumar, Madras rule. In fact, the Delhi rules consideration in O.P. Singla is more crystal clear. And without referring to any of these judgments, that is the view taken by Lordship Justice Gopal Gowda, sitting as a single judge of our High Court. That is judgment at page 289.
Same volume.
Same volume.
Page,
Page 289. Same 83 rules were interpreted. Para 7 at page 298. Judicial service is distinct from civil service. Karnataka judicial service recruitment rules being comprehensive and Karnataka State Civil Services Act being general in nature, the comprehensive rule will have to be applied to the judicial service. At the same time, two statutes cannot be made applicable to a single service, that is a judicial service. Hence, the first point is answered in the negative. That is, Karnataka State Civil Services Act does not apply. That is the first finding. That answers the contention of the direct recruits that you have to make follow Gonal Bhimappa, you have to follow Vivadami, that will not be applicable. Para 8. The next point for consideration is whether the Karnataka Judicial Recruitment Service provides for any quota for direct recruitment in the cadre of district judges from the bar. The method of recruitment to the post of district judges in Schedule 2, Rule 2 of the case is as under. District judges by promotion on the basis of seniority upon merit from the cadre of civil judges, provided that such number of posts as may be determined by the High Court from time to time, but not exceeding in the aggregate 33 1/3% of the posts in the cadre of district may be filled by direct recruitment. The rule provides for filling up of the direct district judges by promotion by selection, not exceeding 1/3 of the posts in the aggregate could be filled by direct recruitment. For that purpose, the High Court has to determine from time to time the number of posts in the cadre of district judges. In other words, out of the total number of posts to be determined by this court as per the schedule to the rule referred to Supreme, direct recruitment could be adopted up to a maximum of 33 1/3 posts or 1/3 of the total number of posts. Thus, there is no quota fixed for direct recruitment while maximum limit is prescribed. Therefore, my respectful submission is whatever posts were there in existence as at the end of 1983 rules, all of them will have to be taken as promotee quota only. For the first time, a definite quota came to be fixed for direct recruitment under the 2004 rules. The 2004 rules is at page 704.
volume,
Same volume, the volume 3 minutes. Volume 3 ಇದು ಪೇಪರ್ ಬುಕ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಲ್ಲ,
ಇದೆ ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ
ಅದು ಸಪರೇಟ್ ಆಗಿ ಹಾಕಿದ್ದಾರೆ.
ಇವರೇ ಕೊಟ್ಟರು
ಓಕೆ ಓಕೆ. ಆ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಹಾಕಿರೋದು ನಮಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಐ ಹ್ಯಾವ್ ಟು ರೆಫರ್ ಟು ದಿಸ್. ನೋ ಡಿಫಿಕಲ್ಟಿ ಮೈ ಲಾರ್ಡ್ಸ್, ಅದೇ ಐ ಆಮ್ ಬೈ ನೌ.
Second one.
this you take this is from library, they could library. 2000 rules, huh?
Simple late. Simple late. Later. Yes.
No matter this 2004 rules, these rules are called Karnataka Judicial Service Recruitment Rules 2004. They shall come into force on the date of their publication in the official gazette. Kindly see the footnote 1 there, Manoj. Published in the Karnataka Gazette Extraordinary dated 9/9/2005, dated 9/9/2005.
Our rules say that they shall come into force from 9/9/2005 ಅಂತ ಬರುತ್ತೆ. ಇದೆ.
ನಾನು ಇದರಲ್ಲಿ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಇದರಲ್ಲಿ ರೂಲ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ. Therefore, vacancy posts that occurred in the cadre up to 8/9/2005. It is a no quota rule. No rule period insofar as quota is concerned. Therefore, having said that promotion is the mode of recruitment, with a concession that maximum up to 1/3 of the posts as may be determined in the High Court may be filled up by direct recruitment, logical inference is that the posts that were in existence as on 8/9/2005 will have to be treated as promotional posts. That is the first premise on which I have prepared that memo. Then, my lords, the on 4/9/2005 or on 9/9/2005, the quota prescribed is, that is at page 705. That is, my lord, sir. Originally, it was 50% by promotion. 50. That is at page 605, my lord.
705.
705. Sorry, Manoj. 705. On the last occasion, I was not present, my lords, because I was indisposed. That is how all this confusion. I thought our side has completed and Mr. Bhagwat would be starting. And I told so much to Mr.
Some people, sometimes suggestions are made that you hear at a stretch. According to me, it's the in-betweens that you reflect on it.
Yes, that is.
Many a time, simply at one stretch you listen,
In
not
fact,
possible for us to absorb.
My lords would remember, my lords, at one point of time, at some point, there was a proposal by the High Court to reduce the lunch recess to 30 minutes. About 25 years back. Then there was a huge protest by all the senior advocates. Junior members of the board, they were not concerned with that half an hour, 1 hour, but we were very particular that 1 hour should be there, because it is the lunch time, the lunch break that we reflect. 1:30 or 1:25 court ಹೇಳುವಾಗ ಏನೋ ಒಂದು ಇನ್ಕನ್ವೀನಿಯಂಟ್ ಕ್ವಶನ್ ಕೇಳಿರ್ತಾರೆ ನಮ್ಗೆ, ಅದಕ್ಕೆ ಆನ್ಸರ್ ಹುಡುಕೋದು ನಾವು ಲಂಚ್ ಟೈಮ್ ಅಲ್ಲಿ. Therefore, we, in fact, senior advocates, at that time I was amongst the junior members of the bar, senior advocates persuaded us, do you know what is going to be the consequence of half an hour lunch break? You may have time to eat, but your mind will have no time to think. Therefore, we should protest for 1 hour. It is the seniors and not the association which led the protest movement, and 1 hour was restored. Then the closing hours of the High Court was extended to 4:45. That is how we overcome that half an hour. It is reflection is only in between the two dates. In fact, I fully share the views of my lords that reflection occurs in between two hearings. That is how it. Now, my lords, on 9/9/2005, when these rules came into force, what item column 3 for district judges prescribed was 50% of the total posts in the cadre shall be filled up by promotion from the senior civil judges on the basis of seniority cum merit. Thereafter, my lords, 25% of posts shall be filled by promotion from the cadre of senior civil judges who have put in not less than 5 years of service as senior civil judges and are within the age group of 35-45 years, strictly on the basis of merit through limited departmental competitive examination. Then, my lords, 25% posts shall be filled by direct recruitment. Therefore, it is on 9/9/2005 that quota for direct recruitment came into effect. Then, my lords, this rule underwent a change with effect from 1/1/2011, or so to say 50%, 25%, 25%. This was in force from 9/9/2005 to 31/12/2010. From 1/1/2011, it became 65% by promotion on the basis of seniority cum merit, 10% by limited departmental competitive examination, and 25% for the direct recruitment continued. Even as on date, this is the quota that is in force. That is from 1/1/2011 onwards, this is the quota. Next question is this, my lords. When the quota is
in All India Legislature Union of India, 25 INSC 35. Again, it is restored to 15, 25.
that's all right. No recruitment has been made after two. My lords, they are in the last but one paragraph of that judgment, which my learned friend is referring to. That is reported in first part of AIR Supreme Court of the year 2026. The penultimate para or third paragraph from the end of the judgment is, High courts and state governments are to take steps to amend the rules. Unless the rules are amended, judgment will not come into force. It can at best be a suggestion, and if my learned friend is aggrieved by non-amendment of the rule, he may perhaps initiate contempt proceedings, not here, but in Delhi. No, not say. Quota has not undergone a change. It is not restored. I submit. At any event, that is irrelevant because we are dealing with promotions made long anterior to the theatre. In fact, All India the Judicial Officers Association judgment number 3, that itself, when they propounded this in-service quota, LDC, they said rules are required to be amended. And they also said it can only be prospective. Two things, I will come to that now. Now the question is, how this quota, which is linked to the number of posts, will have to be operated or will have to be worked out. Because there is a lot of difference between vacancy based quota and post based quota. Now what happens? Suppose today, as on today, there are, let me assume, that there are 200 posts of district judges. And the entire quota is reserved only for promotion. 190, 190 or 180 are appointed already. That means all the 190 posts, when they were filled up and when we were appointed, we were regularly appointed. None of us were in excess of the quota. From today, 25% for direct recruitment is carved out. Now, if quota is applied to all the posts, what happens is 25 of us who were regularly promoted within our quota till yesterday, today we become beyond quota. Our appointments will become irregular. We will lose our seniority. That is why in the High Court of Punjab and Haryana versus State of Punjab, Supreme Court said that quota, new quota cannot be mechanically applied. It will have to be applied only to the increase in cadre strength from the date the quota undergoes a change. And for that proposition, they drew strength from All India Judges Association 3 judgment, where they not only spoke of the in-service quota or LDCE quota, but they also said it shall be applied prospectively. Then they said, when these people were appointed, they were within the quota. By applying the quota rule retrospectively to the existing posts also, you cannot make their appointments irregular. That I will point out. Then I will explain how I have taken that decision. Now, my lords, may kindly take the judgment number 2, volume 1, my lords. That is, my lords, at page 20 of the compilation. Honorable Punjab and Haryana High Court at Chandigarh versus State of Punjab. Paragraph 48, my lords, may kindly turn. Paragraph 48 is at page 44. This court, in All India Judges Case 3, in para 29, has clearly directed that the system which was directed to be put in place by this court, whether para 27, 28, 29, was to apply prospectively. This court had directed that appropriate rules and methods will be adopted by the High Courts and approved by the states wherever necessary by 31st of March 2003. In our court, in our case, it came into effect only on 9/9/2005. Up to 2004, the quota for promotion on the basis of merit cum seniority was 75%, and the cadre strength as on 13/9 was 89, which was increased on 10/11/2007 as 107. After the amendment of rules on 15/1/2004, promotion of 10 officers was made. It is mentioned in the civil appeal of the High Court that cadre strength of Punjab and Punjab Superior Judicial Service before 2004 was 88. Thus, in the year 2004, when the cadre strength was 88, 75% posts were to be manned by promotees under merit cum seniority, that is, 66 were to be manned by promotee officers. The judgment on All India Judges case being prospective, the ratio of officers as existing before unamended rules cannot be adversely affected. A promoting officer before the amendment of 2004 rules who was well within their quota suddenly cannot go out of their quota and become an excess merely on the strength of amendment of rules which are prospective in nature. For determining the quota, the cadre strength which existed prior to amended rules and subsequent to the amended rules have to be treated differently. Promotee quota, which was 75% prior to 2004 rules, makes 66 posts in their quota as before amendment dated 15/1/2004, when the cadre strength has been increased from 89 to 107. 18 posts have to be further added to the cadre. This increase having been made after the amendment of the rules dated 15/1 on this cadre strength, the rules as amended will be applied for bifurcation of quota. On 18 newly created posts, 50% comes to 9, for out of 10 promotees 4.5, and for direct recruits 4.5. That the promotee officers on or after the increase of the cadre could have been 66 plus 9, that is 75. That is quota that existed, number of posts that existed under the unamended rules on the cadre strength that was prevailing on the date of amendment. That should go to the promotees. Increase in cadre strength only can be bifurcated. In the appeal filed by the High Court, it is also indicated merit cum quota, out of con, etc. This is not relevant for working out the quota. Now kindly see the judgment in All India Judges Association 3 itself to have a clarity on the issue. That is in the same volume, it is at page 83. Para 26 is at page 105. Para 26 deals with retirement age. That is not very relevant for our purpose. Only I referred to para 26 because this is also referred in Punjab High Court, the High Court of Punjab and Haryana. Para 27. Another question which falls for consideration is the method of recruitment to the posts in the cadre of higher judicial service, that is district judges and additional district judges. At the present moment, there are two sources for recruitment to the High Court higher judicial service, namely by promotion from amongst members of subordinate judicial service and by direct recruitment. The subordinate judiciary is the foundation for the edifice of the judicial system. It is therefore imperative, like any other foundation, that it should become as strong as possible. The weight on the judicial system essentially rests on the subordinate judiciary. While we have accepted the recommendation of Shetty Commission, which will result in increase in pay scales of subordinate judiciary, it is at the same time necessary for that judicial officers, hard working as they are, become more efficient. It is imperative that they keep abreast of knowledge of law and the latest pronouncements, and it is for this reason that the Shetty Commission has recommended the establishment of a judicial academy, which is very necessary. At the same time, we are of opinion that there has to be certain minimum standard objectively adjudged for officers who are to enter higher judicial service as additional district judges and district judges. While we agree with the Shetty Commission that recruitment to the higher judicial service, that is the district judges from amongst the advocates, should be 25%, and the process of recruitment is to be by competitive examination, both written and viva voce, we are of the opinion that there should be an objective method of testing the suitability of the subordinate judicial officers for promotion to the higher judicial service. Further, there should also be an incentive among the relatively junior and other officers to improve and to compete with each other so as to
excel and get quicker promotion. In this way, we expect that the caliber of the members of the higher judicial service will further improve. In order to achieve this, while the ratio of 75% appointment by promotion and 25% by direct recruitment with higher is maintained, we are, however, of the opinion that there should be two methods as far as appointment by promotion is concerned. 50% of the total posts in the higher judicial service must be filled by promotion on the basis of principle of merit cum seniority. For this purpose, High Court should devise and evolve a test in order to ascertain and examine the legal knowledge of those candidates and to assess their continued efficiency with adequate knowledge of case law. The remaining 20% by the post in the service shall be filled by promotion strictly on the basis of merit through limited departmental competitive examination, for which qualifying service as a civil judge senior should be not less than 5 years. The High Court will have to frame a rule in this regard. Kindly mark that. Merely because Supreme Court says something, it doesn't become the rule. As a result of the aforesaid, to recapitulate, we direct that recruitment to the higher judicial service in the cadre of district judges will be 50% by promotion from among civil judges senior division on the basis of principle of seniority cum merit cum seniority and passing a suitability test. Here in our state, it is still seniority cum merit only. Rule has not been amended insofar as that is concerned. 25% by promotional basis of merit through limited competitive examination of civil judges having less than 5 years qualifying service, and 25% by direct recruitment shall be filled by direct recruitment from among eligible advocates on the basis of written and bio essay test conducted by High Court, respective High Courts. Appropriate rules shall be framed as above by the High Courts as early as possible. Again, reiteration that this judgment will not change the quota unless it is rules are amended. Then para 29. Experience has shown that there has been a constant discontentment among the members of the higher judicial service in regard to their seniority in service. Present writ petition is another experience of the same genre. For over 3 decades, a large number of cases have been instituted in order to decide the relative seniority from the officers recruited from 2 different sources, namely promotees and direct recruits. As a result of the decision today, there will be, in a way, the 3 ways of recruitment to the higher judicial service. The quota for promotion which we have prescribed is 50% by following the principle of merit cum seniority, 25% strictly on merit by limited departmental competitive examination, and 25% by direct recruitment. Experience has also shown that the least amount of litigation in the country where quota system is recruitment exists insofar as seniority is concerned is where a roster system is followed. For example, there is, as per rules of central government, a 40% point roster which has been prescribed, which deals with the quotas for the scheduled castes and scheduled tribes. Hardly if ever there has been a litigation among the members of service after their recruitment as per the quotas. The seniority is fixed by the roster point and irrespective of the fact as to when a person is recruited. When a roster system is followed, there is no question of any dispute arising. The 40-point roster has been considered and approved by this court in R.K. Sabharwal versus State of Punjab. One of the methods of avoiding any litigation and bringing about certainty in this regard is by specifying quotas in relation to posts and not relation to the vacancies. This has already been in our state right from 1962 also. 1962 earliest recruitment also linked the quota to the post. This is the basic principle on the basis of which 40-point roster works. We direct the High Court to suitably amend and promulgate seniority rules on the basis of roster principle as approved by this court in R.K. Sabharwal.
Just one.
You see, we have like, otherwise also, yeah, other states are adopting this 40-point roster. But this also. Oh, that will clear the problem. That's what this judgment says.
This is the basic principle.
ಇಲ್ಲ ಏನು ತಂದೆ ಇಲ್ಲ ನಾಟ್ ಅಮೆಂಡೆಡ್ ಪರ್ಸೆಂಟ್ ರೂಲ್ ಮಾಡಲಿಲ್ಲ
Yes.
ಮಾಡಬೇಕು.
This is the basic principle on the basis of which 40-point roster works. We direct the High Court to suitably amend and promulgate seniority rules on the basis of the roster principle as approved by this court in R.K. Sabharwal as early as possible. Even today's rule regarding seniority has not been amended. Therefore, one of the contentions raised by my learned friend in the writ petition is Quota ought to have been applied because Supreme Court has said so. Supreme Court has also said you have to make the rule and promulgate for it to come into effect.
I think in other high court, in other states, this is adopted.
I don't think because one thing is
In Telangana, we have this Telangana and Andhra.
some courts, what has happened is if you look at the recruitment rules historically, south of Vindhyas, there has always been a quota without a rota. Roster will come only when there is a rota. And mere quota does not imply that there is a rota. If instead of Lordship Justice Kirpal from Delhi, if some other judge would have, honorable judge would have written, I don't know whether the emphasis, so much emphasis would have been laid on roster. The point is, what happens is, though we say that the judiciary should be independent, we may be independent from outside forces, but we cannot be independent of our own prefixations. Punjab, Haryana, Delhi, these are all rota. Paryayettara. One vacancy, suppose 50% is the quota. They will say 1:1. That is, one post by direct recruitment means another post, next post by promotion. And it is settled law that while there is no illegality in fixing a rota, principle of rota, rota is not implied in the quota. Quota rule can exist even without the rota. The two are independent. The two can coexist and they can exist independently also. This is the principle. For that, I am relying on certain judgments. I have referred to in my note. I will take that. The underlying principle in all these paragraphs 27, 28, 29 is what is stated in those paragraphs is what the Supreme Court thinks as ideal solution. But Supreme Court is aware that my thoughts will not become a law unless the concerned High Court and the state amend the rules. Therefore, notwithstanding whatever is stated in All India Judges 3, the seniority and quota will have to be still decided on the basis of the Karnataka rules. Because in service jurisprudence, it is the rules that are having primacy. And in interpretation of the rules, my lords have primacy. That is why I said most of the service law is judge-made law. Because rules are not made by legislature. Rules are subordinate legislation made by executive. When it comes to judiciary, it is in consultation with the High Court. The authoritative interpretation of it is done by the constitutional courts. Therefore, late Mr. P.P. Rao is always, you would say, whenever I enter his chamber in Delhi, he would say, what lawless issue you have brought today for my consideration? And he was telling service law is a lawless law. I used to tell him, sir, you are doing in service law, please don't use it. We are the lawmakers also. Therefore, to that extent, Legislature is excluded. We are supreme. And even the pious hope that they expected, if you link it to rota, seniority disputes will vanish. That was only a heartaceous hope, which is far from reality. Even in January issue of the 7th January, 1st January issue of ARSC, how this rota principle will have to be worked out has been again stated by the Supreme Court. That means 2002 judgment, neither 2002 judgment nor 2004 rules, which came into force in 2005, have put an end to the seniority disputes. It will be there. And there they said the rota principle would not apply if the recruitment from both the sources is not completed in the same year. Otherwise, what happens? Suppose 1:1 or 1:2, 1, 2, 3, 4, that principle is applied. First 2 posts for promotees, third post for direct recruitment, and fourth post for limited department examination. Promotion takes place today. Direct recruitment takes place after 3 years. A person who is recruited, appointed 3 years after my promotion, he will become senior to me because in the roster he happens to occupy the third post. That cannot be allowed. Therefore, they said that rota operation within 1 year it should take place. Then they provided another formula for second year like this. Anyway, we are free from
post Kalida, 10 posts. Out of that, 5 will go to the promotees, 2 for LDC, and 3 for direct recruitment. What he says is all 10 should be filled in that year. Otherwise, you fill 3 out of 5 promotion, 3 you fill this year. Then next year, LDC and this one will fill, and the remaining 2 you fill next year. District judge will come and say that on that day my promotion has to be there. He will be above after 3, he will come as a 4th. So that also again it is clarified in another judgment saying that quota and rota should happen on that particular year only. Otherwise, it will
So
not
you're
work.
saying vacancy based will succeed only if everything is done both on the same year.
same year. But that is not the rule here because the next 3 sentences on that in that paragraph clarify that position. We direct the High Courts to suitably amend the one formal seniority rules on the basis of the roster principle as approved by this court in our case of Raval as early as possible. Next. We hope that as a result thereof, there would be no further dispute in fixation of seniority. It is obvious that this system can apply only prospectively, except though where under the relevant rules, seniority rule is to be determined on the basis of quota and rotational system. The existing relative seniority of the members of the higher judicial service has to be protected, but roster has to be evolved for the future. Appropriate rules and methods will be adopted by the High Courts and approved by the state wherever necessary. This rule making has not happened. Therefore, rotational system of fixing seniority is yet to be born in this state. And my learned friend wants it to be applied from 2015. Retrospective birth is not permissible in rules. Yes. That's all right. If it is not done. But he ignores the last sentence. It can come. My lords, if the High Court has not amended the rule or state has not amended the rule, it may be liable for contempt of the Supreme Court. But it cannot be subject matter of writ petition before the High Court. It cannot be subject matter of a writ petition. Now, suppose even today, the contempt proceedings is initiated. Supreme Court may coerce the High Court and state to implement that by making a rule.
But there's no observation stating that till rules are framed, some arrangement must be followed, nothing.
No. In the absence of a new rule, there is no other arrangement except the existing rule.
Any observations?
It is not like having an executive order in between the two rules. Because executive order can never be a substitute for the rule. Huh? So wherever they wanted some directions to be followed even before making a rule. In exercise of power under Article 140, Supreme Court has said so. In Vishaka's case, for example, when this Article 142 and power to make legislation by judiciary was exercised by Lordship Justice J.S. Verma, heading the bench. He said, this shall be followed until the appropriate legislature makes a law or rules are made. And for decades, we were following J.S. Verma as the rule, that Vishaka as the rule. Then in the matter of police reforms, in Prakash Singh's case, Supreme Court said that this shall be the minimum tenure requirements. Officers, police officers holding operational posts, they should not be disturbed without a minimum tenure of 2 years. Then Director General of Police or head of the police force, in selection of the head of the police force, UPSC should be involved. All these suggestions were made and they made it an interim rule until the appropriate body makes the rules or act by way of a fiat under 142. There is no such direction in these judgments of the All India Judges Association, including the latest judgment which my learned friend wanted to speak of. That I will make available to the court before the next day. I will. In fact, morning I took it out. Then I thought my turn may not come. Therefore, very not. That is, I'm not. Therefore, the rule has to be applied as it is, and not as what is desired by the Supreme Court. As on today, the declaration of saying 25%, 50%, 75% rotation, R.K. Sabharwal, 40-point roster. These are all desires of the Supreme Court. Even desire of a monarch requires a law to be made in a democratic polity. We are not living in a Victorian era where Queen says, you promote him and he is promoted. No. I am proud to say that we are in a democratic polity. Otherwise, I would not have been here. Therefore, my lords, these are the three principles that have to be followed. One is, rule has to be applied as it is. Second is, the quota will have to be applied to the increased cadre strength from time to time whenever quota changes. That means up to the 2004 rule came into force, all are promotional posts. Thereafter, from the date 2004 rule came into effect, up to 1/1/2011, 65%, 10%, 25%. Then from 1/1/2011, the post is 50%, 25%, 25%. Or 65%, 25%, 10%, 25%. And these will have to be calculated on the basis of first increase in cadre strength or the existing cadre strength as on 8/9/2005. Then addition to cadre strength from 9/9/2005 to 31/12/2010. Then third is increase addition to cadre strength from 1/1/2011. This is the basis on which I have worked out. Now I take my lords as to which are the posts that are required to be axed on the basis of the finding of learned judge in division bench judgment. I was at paragraph 66. Thereafter, discussion takes place on what are the posts to be taken into consideration. I avoid all those things. ಅದೇ ತಗೊಂಡಿದ್ದೀನಿ ಡಿಬಿನಲ್ಲಿ ಎಲ್ಲಿಂದ ರೆಲವೆಂಟ್ ಅಂತ ಹುಡುಕ್ತಾ ಇದ್ದೀನಿ. Para 86 onwards. 86 is at page 138. Para 85 onwards it is required. When the learned senior counsel appearing for the petitioners disputed this factual position with respect to increase in cadre strength of district judges, the registry of the High Court is called upon to furnish the details along with relevant notifications by which there was increase in cadre strength of district judges between 2003 and 2016. These two dates are taken, my lords, because our promotion is first batch of promotees were promoted on 30th March 2015. That is on that day, 39 ad hoc judges and senior civil judges were promoted as district judges. 13/8/2015 is the second batch. On which day 41 senior civil judges were promoted. Then comes the direct recruitment of the petitioners. That is on 21/1/2016. On which day 8 persons were appointed as district judges by direct recruitment.
But they took charge in the they took charge in the February. February they took charge. Appointed date.
After the High Court filed a memo, as noticed at para 25, the direct recruits crystallized their dispute only regarding 32 posts. Whatever be the claims they made earlier, ultimately after the High Court filed the cadre strength memo with their respective notifications, they said 32 posts should not have been counted. That finding is at para 86. The High Court has filed a memo dated 8/9/2025, providing the details relating to increase in cadre strength of district judges from 1/5/2003 to 21/1/2016, along with certain notifications for government orders or letters. However, the petitioners have filed objections to the said memo on 10/9/2025, contending that 32 posts mentioned by the High Court cannot be considered as part of the cadre of strength of district judges. The said contention of the petitioners needs to be examined. Then, para 87, the learned judge holds the 3 posts created by notification dated 15/2/2002 cannot be treated as increase in cadre strength. High Court's contention is that it is part of the cadre strength even today in the writ appeal. Now, my contention is also same. Let me assume, for the sake of argument, that every finding given by the learned judge from para 87 onwards is accepted as correct. Even then, my seniority will not undergo a change. Now I'll point out, first finding is 3 posts created on 15/2/2002 will have to be ignored from the cadre strength. Now kindly take the memo filed by the High Court regarding the cadre strength before the division bench. Not this. There is one blue. High Court blue book. Memo file. Yes, this is the one. ಅದು ಬೇರೆ ಒಂದು ನನಗೆ ಕೊಟ್ಟಿರೋದು ಬ್ಲೂ ಬುಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಿಮಗೆ ಬ್ಲೂ ಬುಕ್ ಇದೆಯಾ? ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ದಟ್ಸ್ ಆಲ್ ದಟ್ ದೇ ಆರ್ ಒನ್ ಅಂಡ್ ದಿ ಸೇಮ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಅಲ್ಲ, ಅದನ್ನು format is different, substance is same.
Is it dated 8/9/2025?
Yes, same.
8/9/2025. This is the Mellor side. The new memo they have filed is substantially same. They have added some justifications that would be relevant when we are justifying inclusion of 32. Right now I am arguing you ignore 32 as suggested by Lordship Justice Rai. Even then the position, my position would remain undisturbed in the seniority list.
8/9/25.
This is
This what
15.
ಒಂದು ನಿಮಿಷ ಇಲ್ಲೇ ಇರುತ್ತೆ.
8/9.
What he says is,
Just one.
ಹನ್ನೊಂದದ್ದು ಈ ಕಡೆ ಇಡಿ. ಈ ಕಡೆ ಇಡಿ, ಹನ್ನೊಂದು. ಅದಲ್ಲ ಲಾಸ್ಟ್ ಇಡಿ. ಅದೇ ಇಂಪಾರ್ಟೆಂಟ್ ಇರೋದು ಎಲ್ಲದರಲ್ಲಿ, ಅದರ ಮೇಲೆ ನಡೀತಾ ಇದೆ.
Yes.
Malords, at paragraph 87, learned judge deals with items 1, 2 and 3 of this memo. Page 1 of that memo, if my lords take. Statement showing the cadre strength. It is this memo that is dealt with by Lordship Justice Rai.
ಇದನ್ನ 1 to 3.
Finding at para 87 is the notification dated 15/2/2002, serial number 1 of the memo filed by the High Court relates to a court created for the purpose of conducting trial of a case relating to Dandapalya Krishna gang. Until I read this, I was only remembering Dandapalya gang. Krishna, no, after seeing this judgment, I remembered there was a Krishna in Dandapalya. Another notification dated 15/2/2002, serial number 2 of the memo filed by the High Court relates to a court created for the purpose of conducting trial of a case relating to stamp paper scam. As per both these notifications, condition number 1 stipulates that post was created only for a period of 1 year and prior approval was mandatory for continuation of the said court. Condition number 5 also expressly states that no new recruitment could be done for the said court. Further notification dated 27/12/2003, serial number 3 of the memo filed by the High Court relates to a court created for conducting trial of a case involving late Kumari Jayalalitha. These 3 courts are temporarily created only for the purpose of conducting trial in specific cases, and upon conclusion of such trial, the said courts would stand abolished. Even otherwise, the trial of the cases in all these three have been concluded several years ago, and there is no justification for continuing such courts thereafter. Thus, these three posts cannot be considered as increase in cadre strength. Now, kindly take this memo 1, 2, 3.
Like whatever may be. Yeah, they can challenge on this.
They go.
But they are born in 2016. Huh? ಮಾಡ್ಬೋದಾ?
And also it's a actual aspect. Even after that, they may have continued to work. We don't know.
They have continued, my lord. There is nobody sent out because this is flawed on two grounds. One is cadre can include temporary posts also, not necessarily a permanent post. Second is a temporary post can be held by a permanent employee or a substantially promoted person or substantially recruited person. So suppose today a temporary post court is created. Do we post a temporary district judge to head it? Or can we say that senior civil judge is put as in charge district judge? Because it is a statutory function. It is jurisdiction is vested in the district judge. Even if the court exists for one day, on that one day also district judge can preside over that court. This matters. I am with
Looking at another way of looking at, they would have said that existing first additional judge Vijay Kumar, who is a district and session judge,
Sometimes what on the administrative side, there are certain district courts which are vacant. What we do, though the civil judge senior division may not be ripe for promotion, we say that ad hoc, whatever. At some point of time in future, while they're performing, we say, let us assume after 1 year, a substantive vacancy in the district judges does arise. So though he may have come as ad hoc at the first instance, by lapse of time, it becomes substantive.
that is exactly what has been done by the first notification by which 39 persons were promoted. There the notification reads promotion of ad hoc district judges and senior civil judges as district judges. And their seniority has been counted only from the date of their regular promotion, not from the date of ad hoc promotion.
anything just
My lords, if the learned judge had said that these are the number of promotees in the cadre as on the date I was promoted. This is the quota of number of posts available. That is for the district judges. Promotion of X, Y, Z, AA, it is in excess of the quota. If such a finding had been given, then, my lords, yes, it is a definitive finding. Without any basis, he assumes trial has concluded, therefore court has gone. Along with that, district judge also has gone. Where is the investigation? But with a heavy heart, I am assuming his findings to be correct and trying to argue that even then the ultimate setting aside the seniority list is wrong. It is not that I am a votary of the finding of the learned judge. With all the humility at my command, says it is impermissible finding based on sketchy facts based more on imagination and the non-understanding of the fact that even a temporary post will have to be headed only by a substantial district judge as or ad hoc district judge, and no ad hoc for ad hoc period no seniority has been given. These are all cases. Telgi's case, only that is the only name he has not mentioned. Therefore, I just to complete the record, I said Telgi's case. Telgi's case was tried by a senior district judge. Jayalalitha's case was tried by, I think, senior most of the district judges, that is Justice Michael Kunna. They were not tried by ad hoc judges. In fact, ad hoc judge could not have headed those.
That's one. No, we have to call for everything back. Permission, everything take back.
No, my lords. For items 1, 2, and 3, the learned judge requires us to remove from the cadre strength. Then, next paragraph, para 88, it deals with item number 7 in the memo. What it says, the office order dated 23/2/2005 issued by Additional Registrar Administration, Supreme Court of India, serial number 7 of the memo filed by the High Court, would indicate that one Sri N.S. Kulkarni, Additional District and Session Judge, Mangalore, is deputed as member judicial of the E Committee. A sanctioned post in E Committee of the Honorable Supreme Court cannot be considered as part of cadre strength of the Karnataka judiciary. My lords. Supreme Court says a post is created in the Supreme Court which has to be filled by deputation of a district judge from Karnataka cadre. It definitely increases the cadre strength of Karnataka cadre because it becomes an ex-cadre post encadred in the Karnataka judicial service, because the post may be outside the cadre of district, outside the district judiciary in Karnataka, but it is a post in Delhi which has to be filled by deputation of a district judge from Karnataka. It adds to the cadre strength of Karnataka as deputation reserve. In fact, my learned friend himself has produced 2 notifications in volume 3 of the paper book, which speaks of the deputation posts and leave reserve posts. There is no whisper of those posts in the order. That notification cadre strength as on 1/1/2000. That is, my lords, at page.
E committee
Alala.
can build up any state, not just Karnataka. For a registrar to be not visiting in the Supreme Court. Can it be from Karnataka? No. Any of the state all over.
That does not mean. Fact remains that a person from Karnataka was deputed. Is he not part of the cadre strength of
I'm not
Karnataka?
saying that.
Are you deputing a?
Any state is taken.
Whether deputation reserve, which was filled by Karnataka district judge, can it be added to Madras, Maharashtra cadre strength? It has to be added to the cadre strength of Karnataka only. Kindly see page 702, volume 3 of the paper book. This is
produced.
Yeah, then ನಿಮ್ದೇ ಹೇಳ್ತಿರೋದು.
Not to show that there must be cadre check notification.
It's all right. I can take advantage of the contents of that.
I'm producing that.
One cadre strength notification produced, it shows that there is deputation reserve and there is leave reserve.
ಇವರು ಈ ತರ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
When were these deputation reserve and leave reserve posts abolished?
Sanctions.
There is no notification abolishing them.
This is that K80, not division member. Is that?
Yes, please.
This is that.
We are not in a dialogue, Mr. Bhushan. You will have your turn. Please have patience to note down what I say and answer. Don't interrupt. And I have already told on the first day, I refuse to be derailed.
You are telling he committee member, how he can happen like that? He committee member of Supreme Court of any state. How could you can argue like that? And fight for this.
It's
He
just
has not got reply.
you
How
will-
could he can argue such
he
things?
will-
First
I
of all,
am-
how court can be appreciated? How could the fact?
I am arguing on the
It is not
basis
like
of,
no. Let me give him 19
I-
minutes and answer it.
on,
This is not the way not to address the argument. If they fight reply,
yes,
he will make comments.
we learn from
And I am not
experience.
objecting here.
ಆಯ್ತು ಅವ್ರು ಹೇಳೋದು ಹೇಳಿ ತಾವು ಇರ್ರಿ ಒಂದೇ ನಿಮಿಷ ಆಮೇಲೆ ನೋಟ್ ಮಾಡ್ಕೊಂಡು ರಿಪ್ಲೈ ಮಾಡಿದ್ರೆ
I am
ಅಂಡರ್ಸ್ಟುಡ್
not,
ಫಾರ್ ವಾಟ್ ಪರ್ಪಸ್ ಯು ಆರ್
I
ಪ್ರೊಡ್ಯೂಸ್
am making what? I am
it is a document produced by him.
ಇರ್ಲಿ
Yes, they are concerned.
It is a document filed by him. It shows deputation reserve 46,
7
leave reserve 33 plus 2.
leave reserve 33 plus 2.
And even in IAS, IPS, Indian Forest Service, 16, about 25% of the cadre strength is provided as deputation reserve and leave reserve. Because every judicial officer is entitled for 30 days privilege leave, 15 days, what is that? Half pay leave, no, full pay ಮಾಡ್ತಾರಲ್ರಿ, commuted leave, and 12 days casual leave. That means, as a matter of right, he is entitled to be on leave for 57 days in a year, which comes to 1/6 of the 1/6 judge. If there is 6 judges, 1 judge is required as leave reserve alone. 16%. I think in All India Service Rules, it is provided as 16.5%. Then deputation reserve. Today, how many posts are required to be filled by deputation? We should not chase this shadow. We have to see the substance. Only Arjuna can see the shadow and shoot. We are not Arjunas. From there, we have moved to the rule of written book. Now, my lords, coming back. I did not get derailed. I am coming back to para 89. Para 88. He says, since state government has not issued a notification, that post has to be excluded. Not on the ground mentioned by learned friend. Then para 89 is item 8. It is claimed that as per the notification dated 31/10/1991, there was increase in cadre strength of 1 post of district judge. The note appended on page number 4 of the note show that said post was considered as part of the cadre strength from 1/8/2005 as a judicial officer was posted in the said post for the first time. However, reading of the notification that reveals that it relates to amendment to the High Court Service Rules 1973, whereby nomenclature of additional registrar is substituted by registrar judicial and registrar administration. This notification does not relate to creation of post or increase in the cadre strength of district judges. Even otherwise, as per the method of recruitment prescribed in the recruitment rules relating to said post, they can be filled by promotion to the post of deputy registrar or filled by posting a person who has been a district judge. Though the post is validly created on the establishment of the road, the said post need not be mandatorily filled up by serving a district head. There is no also notification to the state government in concurrence with the finance department for making this post as part of the cadre strength. Thus, this post also cannot be. Therefore, what he says is items 1, 2, 3 and 7 and 8 have to be excluded. Now come back to the memo. As on the date of commencement of 2004 rules, that is on 9th September 2005, the cadre strength as per this memo is 172. Of this, items 1, 2, 3, 7 and 8 are to be excluded. Even if we exclude that, the number of posts in the cadre as at the commencement of 2004 rules were 167. 172 minus 5, it will become 167. Therefore, in my memo of calculations, I have said all these 167 posts will have to be treated as promotional posts, because that is the position under 1983 rules. My lords asked at the threshold, up to what date we can go back and ಕೇಳಿದಿರ್ತಾವೆ. Then I said, because their contention is beyond 1 month, up to 2001 there is no confusion, because the cadre strength notification they themselves have produced. Dispute, if any, can be only after after 2002, and 2002 onwards this court directed them to file a memo. They have filed. Therefore, we can take that dispute as arisen from computation of vacancies from the year 2000. Because the first dispute they raised is about 15 to 2000. Now, on 1 month,
Just 1 minute, just 1 minute. Finally, when at the end, we wanted to touch upon the point, how far can they legally open? Now, if all this is, they came in only in 2015, 16.
Yes, ma'am.
Now, all this, if you are saying theoretically, you redo all this, etc.
I am only
No, no, I'm
yes.
saying that if at all the point raised is that it has total thing, there is a lot of error, etc. So in law, the argument was advanced that you cannot challenge something before you enter.
Yes, ma'am.
That one point in the end, you just
Because that manors, yes, I will answer that manors. Because existence of posts, how many,
Is not understood.
how it has to be gone about. I took this contention because
no, the entry, yeah, the
up to what date we can go back.
direct recruit,
Yes.
direct recruit.
Challenge
So once he enters in, he's
from up to there to go back.
how far back
He can
could he challenge?
Yes, ma'am.
born in the cadre.
Whether a direct recruit of today can challenge the seniority of persons born in the cadre before he was born.
Yes.
That is the question.
That one subject, however, to the rider,
Yes.
wherein they would contend, perhaps, that if there is a imbalance in that,
We
you
are
say,
entitled to
promotees, we could still challenge it.
That will be their contention. Then one of the question would arise as to how far backwards we can go to correct a mistake. Assuming there is a mistake, can we correct the mistake or injustice that occurred to Dharmaraya after centuries have moved on? It is like telling my lords, Dharmaraya ought to have been made a king without Mahabharata war. Can we correct it today? We can only learn lessons for the future. In fact, in one case, which went from Andhra Pradesh High Court regarding the recruitment, Lordship Justice P.V. Reddy. On him we have also claimed because he was our Lord Chief Justice. He said, even a mistake cannot be corrected after the delay was there only 1.5 years after appointment. Challenge was raised. He said, after 1.5 years, you cannot approach the High Court to correct it. Lordship Justice Shiv Shankar Bhatt took a view here that Administrative Tribunals Act prescribes a limitation of 1 year. One appointment was challenged 6 months after the appointment. Heading the Karnataka Administrative Tribunal, Lordship Justice Shiv Shankar Bhatt took a view. You may be within limitation, but your application suffers from latches. That was confirmed by the Supreme Court in Prakash's case. It said, tribunal is right. Like we do in the suits for specific performance. Suit may be within limitation, but if it is barred by latches, specific performance will be denied. All these things, I will address that, my lords. As on today, I have not applied my mind on that aspect of it. Therefore, my lords, what is shown in this memo as 172 as at the commencement of the 2004 rules. Instead of 172, it becomes 167. And this one.
Are you referring to the notes dated 9/1/2026?
No, I am not referring to the note right now. Next, after showing this, I will refer to the note. Now, the notes, if you take my note, 9/1/2026. That is what I have said in para 6 of para 5 and 6 of my memo. Para 5, what I have said. 1983 recruitment rules at page 691, under which there was no in-service quota and there was no quota for direct recruitment, were in force until 8/9/2005. The 2004 recruitment rules, page 704, came into effect on 9/9/2005. Sanctioned cadre strength as on the date of commencement of 2004 rules, even after axing pleaded by the petitioners and accepted by RRKJ, will be 172 minus 5, being aggregate of items of 1, 2, 3, 4, 5 I have written, it should be 7, 8. 1, 2, 3, 7, 8. That is equal to 167. Therefore, these 167 posts will have to be treated as promotion posts, only having regard to judgment of the Supreme Court in Ashok Kumar and of this court in Shambhalingappa, and we can usefully add under the Supreme Court in O.P. Singla.
That is left. Gopi.
O.P. Singla. That is 1984, 4 SCC 450. Then, my lords, axing under 2004 rules, which are the posts that learned judge has axed. Kindly take paragraph 90. The notification dated 5/12/2005, serial number 9 of the memo filed by the High Court, relates to 6 posts of chairman of permanent Lok Adalats, that is, 1 each at Bangalore, Mysore, Mangalore, Dharwad, Belgaum, and Gulbarga. Section 22B of the Legal Services provides for establishment of permanent Lok Adalats. Section 22B2A of the said Act provides that post of chairman Lok Adalat can be filled by a person who is or has been a district judge or has held an officer higher than the rank of district judge. merely because a district judge can be deputed to the said post, these 6 posts cannot be considered in the cadre. This is flawed for the reason. According to the learned, there are several methods of recruitment. Administration decides to choose one of those several methods available. One method is available is by deputation of district judges. Is the appointing authority barred from exercising that choice merely because other choices are available? Till today, till I read this paragraph, I was under the impression that courts would interfere when the method chosen by the executive is one not permitted under law. When more than one method is permitted under law, and one of those permitted modes is chosen by the executive, judiciary has no say in that. But here a finding is given. Other methods are also available. Only one of the methods is by deputation of district judge. Therefore, it cannot be added. It is for the administrator to choose from out of several methods available. This is what is said even in respect of economic policies, Ranganath Reddy versus state. Nationalization of contract carriages in the state. To achieve a particular socio-economic objective, several instruments are available. Several alternate methods are available to the state. Only thing that the judiciary can question is whether the alternative chosen is one permissible by law. Here, learned judge accepts that deputation of district judge is one of the methods, but says, since other methods are also available, you cannot add this to the cadre strength of district judges. How far this is within the scope of judicial jurisdiction for judicial review? But again, I assume this is also correct. And let me proceed. Then, next he thinks is para 91 relates to 2 posts of additional, each post of additional registrar generals. Learned judge now say 6 district judges are not occupying the permanent Lok Adalat, or 2 district judges are not occupying the posts of additional registrars. Even today they are there physically. The notification dated 30th April 2008, serial number 14 of the memo filed, relates to 2 posts, to each post of additional registrar generals of this court at Dharwad and Kulbarga. Notification dated 2/8/2013 is related to 3 posts of registrars, recruitment, infrastructure, maintenance, and statistics and review. Notification dated 6/1/2024, serial number 32 memo filed, and registrar judicial and registrar administration of this court. The method of recruitment in respect of these posts is not exclusively from the cadre of district judges. Is it barred by filling up of district judges? It is one of the methods. No finding is given by the learned judge to say that these posts have been filled up by some other method. A lawfully available choice by deputation of district judges is acted by the learned judge. What are these items? Serial number 32, serial number 14. Now what does this add up to? Item 9 in the memo. You, my lords, would kindly take the memo filed by the High Court regarding the cadre strength. So, after the commencement of 2004 rules, What he says is 9 should go, then 14 should go, and item 23 has a very significant finding.
32. 32 ಅಲ್ಲ?
The next item that has to go is item 30.
What about
9,
23?
9, 14 and 32.
9, 14
32.
and 32.
23 also.
What will have effect is only
12 posts.
9 and 14. Before on the date the quota changed. Again 50, 25, 65, 10, 25. That is in between commencement of the 2004 rules and amendment which came into force on 1/1/2011. The items the learned judge has ordered to be axed is only
9 and
item 14
9 also.
and item 9. That is 6 plus 2, 8 will go. Further action comes in the third block.
Quota change ಯಾವಾಗ ಸರ್ ಯಾವ ಡೇಟ್?
Now therefore,
Quota
if
change.
item 23 my lords would take,
Quota change on date.
just minutes,
Quota change date.
1/1/2011.
Yes.
So that is 23 is the last one.
Only 2 will go. This is after that.
Therefore, as on 1/1/2011, the cadre strength as per this memo filed by the High Court is 199. From that, items 1, 2, 3, 7, 8, 9 and 14. If it is excluded, total exclusions will be
5.
13 will go. It will become
13 will go.
instead of 199, it will become 186. Now of this 186, 167 existed on the date of commencement of 2004 rules. They will have to be treated differently as per the quota existing till then. Therefore, the number of posts available for allocation under the 2004 rules till their amendment is 19. That is 186 minus 167. That is equal to 19.
6.
186 or 167?
186 minus 167.
This 19 will have to be allocated between the three quotas as 50% for promotion, 50% for direct recruitment, 25% for direct recruitment, and 25% for LDCE. That is what I have said in paragraph 7. Paragraph 6 only. I have taken 24 as the increase. That appears to be slightly wrong. That has to be reworked. If 19 is the increase, then 50% of it, 10 has to go to for promotion. The other 9 will have to be distributed among the two, LDCE and the That is it. I have taken the cadre strength as on that day as 199 instead of 186. I have to take as 186 minus 167. It comes to
167.
19. These 19 posts will have to be allocated as 10 4.5 for 4.5. But in the order in which they are arranged in the recruitment rule, promotion comes first, 10 will go. LDC comes next, they will take 5. Direct recruitment comes last, it becomes 4. This is the increase. Then we come to para 92 onwards. Here, for whatever reason, Leonard Judge access serial number 24. There again, the reason given is alternate methods of recruitment are available. It need not be by deputation of district judge alone. Therefore, Benakanalli cannot be added to the cadre strength. Then para 93, serial number 33 is taken into consideration.
This is memo ಕೊಡೇ ಇರಲ್ಲ appellant high court ಕೊಡೇ ಇರಲ್ಲ
ಅಲ್ಲಿ ಬರೀ ಇದಿದೆ ನಂಬರ್
names ಬಿಟ್ಲಿ ಅವ್ರಿಗೆ
So these details were furnished by the petitioner,
Yes, ma'am.
names of the officers.
Names of officers, everything I think they have furnished it, and I don't know what they furnished it. But it is presumed that since it refers to the memo filed by the petitioners in answer to the cadre strength notifications produced by the High Court, it should be presumed that they have, anyway, that my learned friend would say whether they said the names and all that. Luckily, it's only the Benakanalli's name that comes. The rest of the things are. Then, my lords, para 93. So, the items that the learned judge access are item 24, item 33, which is one post. Then similarly 34 is axed.
According to principles around, we have asked them to redo. We can't sit and do all this.
No.
It's a judicial review.
Ah,
24, 33 and 34 are the
Mathematics.
items axed in the next group. They add up to 3.
There's also another way of looking at it. Though we are doing this exercise, we'll go through it.
Yes.
Because we are looking through. Broadly speaking, if the court were to come to a finding that there is something wrong in the application of principles. That is an aspect to be redone by the employer.
Yes. Now the question is, if even after axing 32 posts, my seniority would not have been affected, is there a need to annul the seniority list? Because my grievance is seniority list giving me a particular rank in the seniority list has been set aside. At one point of time, it was the judicial view that seniority right is a civil right and it is not a constitutional right. It is not a fundamental right. But that underwent a change by two judgments rendered by Lordship Justice Jagannath Rao. Lordship Justice Jagannath Rao took the view, first in Ajit Singh 2, and thereafter in some other judgment which went from, I think, if I remember correctly, Jammu and Kashmir. Look, promotion is related to or interlinked with seniority. And I have a fundamental right to be considered for promotion. By changing my seniority, my right to be considered for promotion, which is a right in me under Article 16, is denied. Therefore, right to seniority has a dimension of Article 16. Therefore, the question is, even making all the corrections that the learned judge suggests or holds is required to be made, if my seniority above the direct recruits is not going to be affected, there could have been no direction to quash the seniority list. My respectful submission is, excess recruitments have taken place, but that is under LDCE quota, not under promotion quota. And to render a finding whether LDCE promotions are in excess of the quota, no appointee from LDCE quota is made a respondent. Even in the matter of seniority, the persons should be made parties at least in a representative capacity. Earlier there was a confusion that whether everybody should be made a party. Then in one or two judgments they said it is enough if it is made in representative capacity, a few of them. Ultimately that issue is resolved by three-judge bench in what is that latest? In one of the judgments that not Prabodh Verma said that was pertaining to appointment. There is now the position, settled position in law is that they should be made in representative capacity. Nobody has been made a representative, yet even in representative capacity. No LDCE has been promoted, has been made. Therefore, my respectful submission is, even if the court goes into that question, no finding can be given in the absence of any LDCE before the court. Therefore, all that can be said is that prima facie LDCs are in excess, but I cannot decide on that issue because no LDC is before me. I think that would be a solution which would be in tune with natural justice, which would be in tune with this settled law about upsetting the seniority. Because this court cannot determine as to how many have to be excluded, though the learned judge has gone into that exercise. And prima facie, those reasons given do not meet the standards of the norms of choices available to the executive. The net judge does not say it could not have been filled by deputation. The net judge accepts that it can be filled by deputation. But he holds the actually post because that is only one of the methods, as if it is not a method at all. Therefore, my respectful submission is seniority list has to remain. A prima facie view can be expressed because my lords are deciding whether I am an excess promotee or not. Then it has to be said that seniority list may contain some errors, but there is a matter the executive has to redo, that is the administration side, it has to be redone in accordance with the principles of natural justice. My position has to be protected because I demonstrate that applying All India Judges Association 3, applying its interpretation in High Court of Punjab and Haryana, and the rule position, even if the 32 posts are axed, I cannot be said to be a promotee in excess of the promotional quota. Quota has to be determined under 83 rules in terms of OP Singla. Subsequent increases have to be accounted in terms of the High Court of Punjab and Haryana. If that exercise, assuming the numbers determined by the learned judge, or even assuming the High Court view to be High Court administration to be correct, either way, my position in seniority vis-a-vis the direct courts will not undergo a change. That is what I would like to humbly submit ultimately. And Quota is not implied in Quota 1 or 2 judgments, I will cite. Conclude my submissions.
And about the other issue also, with regard to whether they can question the.
Whether how long we can go back.
Go back.
Yes.
And they are born the system in the year 2015.
Yes, yes.
How long we can go back?
Yes, how long we can. Good. I'm sorry.
We'll continue tomorrow.
We'll continue tomorrow, 2:30.
2:30.
Tomorrow, 2:30.
Very good.
He has completed.
Mr. Bhagwat will start, is it?
Yes, ma'am. I just.
Let him answer on-
Hmm?
let him answer on
Yes,
this.
I'll
This
help
last
him.
query of tomorrow. Then back.
That one query we wanted you to answer.
Two queries are there, my lords, not one. One is whether there can be a quota without a rota. That I have to cite. Another is how backwards we can go. And whether a subsequent direct recruit can charge the earlier. These three issues I will answer and then.
Ah, that's okay. That's okay.
I know how much time I am going to.
No, no. No, finally, the endeavor must be that the judge understands.
Yes, ultimately, my lords.
So,
All of us should be on the same page insofar as the understanding is concerned.
Not saying anything, but how is we are doing the right to all. That is our answer. I assure that will happen.
so far as officers, this is a big task.
Well, for them, it is a question of life and death, because life and promotion.